Swayam Prabha. Digital India. Educated India.
Warm greetings to all of you. Once again, I would like to welcome you all, dear students. I am Dr. Raju Maji, Assistant Professor, Faculty of Law, Banaras Hindu University, Varanasi. So, in the series of the lecture of Law of Banking and Negotiable Instruments, in this particular lecture, that is lecture number 11, and under which I would like to say with the many, or you can say very important aspects which is required as far as concerned to apply with the negotiable instruments, that is endorsement. So, nothing to be worried about it, that little bit is a technical or the you can say the subject matter, but I will try to explain in a very simple manner. As far as concerned that the endorsement, why it is required, when we are talking about the negotiable instruments, we will discuss in the next lecture, that is the negotiable instruments in detail. But as far as the negotiability means the transfer of any instrument. So, the before transferring that you can entitle the some other persons, and that the process of entitlement we are doing through the endorsement. And generally when we see the endorsement, it is nothing, it is a kind of you can say the process through which we are the holder is enabling the other persons by transferring that the other persons is also entitled to be or you can say the right entitlement. So, the endorsement we will see in that process. So, this lecture covers very important aspects of banking law, as I have already told you, and that is the endorsement. Endorsement is one of the very significant part of negotiable instruments, and when we will discuss the negotiable instruments, then the negotiability, the transferability, that is one of the very important aspect of Negotiable Instruments Act. So, the Negotiable Instruments Act under section 15 of the Act, it defines the endorsement, we will see in details. Besides this, let us see what are the objective of this. We will see that how the endorsement can be regulatory. We will see the various kind of you can say the endorsement which will have. We will see that how this is working or functioning, or what are the you can say the obligations lies towards the endorsement towards the you can say the endorser or the endorsee, that will be discussed. So, to understand this particular chapter, I have decided to discuss the endorsement in 5 heads. The one, the meaning and definition of endorsement. Then the second head is the objects or significance of endorsement. The third one is the kinds of endorsement. Then we will see the very important aspects of that is legal provisions regarding the endorsement, and finally, we will see the regularity of endorsement, because the regularity of endorsement is very you can say the significant part of endorsement. So, let us journey this discussion, or you can say complete this journey by understanding that what do you mean by the endorsement. Again, I would like to mention here that as I have told you that the endorsement is entire sections that is or provided under the Negotiable Instruments Act. So, the meaning when we are talking about, then meaning can be understood that an order check requires endorsement before delivery. That means that there the delivery, that the negotiability can be done through 2 ways. The one, it is possible through the mere delivery, that when I have as a holder or as a maker, when I am giving an instrument, the negotiable instrument to someone, that I can do by mere delivery. But and the other is that before delivering, I am putting his name and I am putting my signature. When I am doing that, that process comes under the definition of a endorsement, that I am endorsing it. So, that is the process of endorsement. So, but as far as concerned, the word endorsement is also spelled the endorsement. So, this if you go through the books or the dictionary, then you will find that the 2 words are which is used as far as concerned that the endorsement. One is ENDORSEMENT, or it begins with the I also, the INDORSEMENT, So, both are, it's a choice of the scholars, they are applying or they using the meaning thereby the same, there is no change. But as concerned how this word came, that is a very big question before us. So, to understand that, the scholars mentions it says the word endorsement is derived from the Latin word, that is endorsum, INDORSUM, the endorsum, how it is then, and it, which means it says upon the back, means upon the back, in means upon, and dorsum means back. So, upon the back, the endorsum means upon the back. I will tell you the later on that how this word has been derived, and in the practical whether it is applied in that way or not, that is very important, or you can say the significant part of it. So, as the derivation suggests that usual place for an endorsement is upon the back of the instrument, but nowhere it is mentioned that how the endorsement can be done. But as far as concerned that the words which is derived and the derivations of this word, it suggests that the endorse can be done in the back of the instrument, that is very important. But as far as concerned, again I am reminding you that nowhere it is written under any you can say the section, it is not talk about it, that what, how it can be made. So, an order check, as I have told you, that requires the endorsement before delivery. Endorsement is nothing but the process of signing one's name or affixing an accepted rubber stamp impression on a check for the purpose of transfer. Thus, it is both the contract and a transfer. The delivery of the instrument is necessary to complete its endorsement. Now, let me explain the few things. As I have told you, the endorsement, if we are trying to understand, it is nothing. As soon as the holder, when I would like to transfer that instruments to some other persons, because it is the beauty of the negotiable instruments that it is negotiated, and the negotiated here means it is transferring from one hand to another, and it will continue till the payment will be made or the maturity period will expire, whatever may be. In these two conditions that it will stop, otherwise it will run or it will transfer or it will undergo through the one hand to another hand. This is the beauty of the negotiable instruments. So, the endorsement, when we are transferring it, the persons as a holder, I am putting my signature and I am transferring to the some other person. The putting signature and mentioning his name, that is the process of endorsement, that is called the endorsement. So, the endorsement, that by putting signature, or sometime that what happens that like this the natural persons, that the rubber stamps and the other things also be used. So, there is nothing to be, you can say, the restrictive that can be used in that way, whether you can write it, you can write and you can put your signature, and you have a right that to make or to instruct or to pass some sort of, you can say, the instructions as soon as you are endorsing that documents. So, as far as concerned the legal definitions that has been given, the word endorsement is defined under section 15 of the Negotiable Instruments Act 1881. Let me allow to read out these provisions. The section 15 of the Negotiable Instruments Act 1881 provides the definition of endorsement. It states that when the maker or holder of the negotiable instrument signs the same, otherwise than as such maker, for the purpose of negotiation, on the back or face thereof, or on a slip of paper annexed thereto, or so signs for the same purpose a stamp paper intended to be completed as a negotiable instrument, he is said to be endorsed the same and is called the endorser. How beautifully defined as the general meaning which I have mentioned before you. I have stated that in the same way the definitions is also given under section 15 of the Negotiable Instruments Act. That is the last word. If you will see that the persons who is endorsing is, he is called the endorser. For suppose A, he as a holder or maker, besides the maker, whenever he is putting his signature and he is transferring or delivering to some other persons, the endorsement is complete. Now, the question is whether it is a blank endorsement or the full endorsement, that is we will discuss when we will discuss the kinds of endorsements. So, nothing to be worried about it, but at one person it is talking about that can be done through the signature or for the same purpose a stamp paper intended to be completed as a negotiable instrument, he is said to endorse the same and is called the endorser. That means the person who is endorsing it, he is called under the section 15 of this act, that is endorser. It is quite evident from the above mentioned definition that the endorsement can be made either on a back of the instrument or on the face thereof. But again I am telling you, the practically if you will see that to distinguish the maker, for example, if in the front side the check, when the maker is preparing a check, his sign is, you will find in the just in the last, the right side of the corner. So if some other persons will put its signature on the face of that instruments, in the front of, you can say, the check, so it will create some kind of the difficulties, or you can say the confusion before the paying banker or the collecting banker. He cannot identify that. That's why it is practically it is accepted that the signature can be put, or you can say endorse must be done in the back of the paper, and the word which you have taken, that the same thing is talking about, that is the back of the instrument. But as far as concerned the section 15, it is not talking about that it must be put, because it is talking about either in the face or in the back of the instrument when the person is putting its signature and he is delivering to some other persons that the endorsement, the process is completed by putting his signature. The second things which I have mentioned at the very beginning, that what do you mean by we can say that the endorsement, we got the answer that the endorsement means a process where before the delivering, or you can say the negotiating, the holder or the maker, except the maker, he is putting his signature on the back of the documents. And for example, suppose the documents is completed, there is no space is available, then how the endorsement can be done. And for this purpose, the section 16 is also talking about that you can, section 15 is also talking about that a paper can be attached, that is the stamp paper, or even such other papers can be attached. When you are attaching it, it is called the allonge, A-L-L-O-N-G-E. The allonge term you will find when you will read some book, then you will find, and nothing to be means the worried about that, what do you mean by the allonge. Allonge, the section 15 which is talking about, in the addition to that, when you are attaching a paper, that paper will be termed as an allonge. So the objectives or significance of the endorsement, that is very important. Let me allow to tell you that what to mean by this, and what are the, you can say, the significance, what are the importance of endorsement, why the endorsement is required, why endorsement plays a very significant role as concerned to regulate the negotiable instruments. It's a very, because the instruments, the parties are there, we will discuss in the next lecture, but as concerned that at this moment, just I like to tell you that it doing for the purpose of the negotiating. So the endorser of a negotiable instruments, by his act of endorsing, signifies the following to his endorsee and to any subsequent holder, that when the instrument left in his hands, as I have told you, that the negotiating means that we are transferring from one hand to another hand. As far as the negotiation that can be completed without putting any source of the signature, it is by mere delivery it can be completed. But as far as the endorsement, when we are talking about, the parties are putting its signature on the back of that instruments. As soon as he is putting and he is handing over to the other or delivering to the other, that the endorsement is completed. So when it is completed, the purpose or the significance of the endorsement, as I have told you, that it will plays a very significant role for what it said, the endorser of a negotiable instrument by his act of endorsing signifies the following to his endorsee and to any subsequent holder, that when the instrument left in his hands, that means it will gives one kind of, you can say, entitlement. It creates the authenticity that the person who is possessing that document, he is the holder of that, and as a holder he has a right to negotiate further. Unless and until you have that right, you cannot negotiate further. So the title, it gives, you can say, the one kind of the title to the persons who is possessing that documents. When he is receiving from some other persons, that the titles can be you can say the defective free. For that purpose, the endorsement plays a very significant role. So, the significance of this, it says it had a good title to it. The first and foremost thing as far as concerned, that when the endorsement is taking place, so the relations will develop between the two, the persons who is holding the documents and the persons who is endorsing the document. The persons who is endorsing the documents, he will be called the endorser, and to whom it is delivered, he will be called endorsee. But as far as concerned, that the endorsee becomes a holder of the document. Endorsee become the holders of the document, and holder unless and until he had the title of that. How his title? For example, if I am writing on that instrument, pay to B, and I am handing over to the B. Now, as soon as the B received that instrument, B is entitled. Why? Because his name is appears, and as a previous holder, I authorize him that I transferred my title. Earlier, I had the rights, but as far as concerned, now I have transferred the title to whom? I transferred the title to B, and the B now he is the entitled on the document. He is the possession, and as a possessor, he is become a holder, and the holder got all these rights to further transfer, to further negotiate. So, he will get the first and foremost, you can say, the endorsement gives the entitlement to the persons who is possessing that document. In other way, we can say the persons who is holding the document becomes a holder, and the holder get the title of it. Further, it says the instrument was genuine in all its particulars at the time of his endorsement. When it is gone through one hand to another hand, at that time, naturally, we will examine that whether the document is right or wrong. The contents which are written there, whether it is correct or incorrect, that will verify with the help of the endorsement. So, the another significance of the endorsement is that it is checking the genuineness of all its particular at the time of his endorsement. The third significance of endorsement is that all the previous endorsements were genuine. Thus, section 122 of the Negotiable Instruments Act 1881 provides that it states, no endorser of a negotiable instrument shall, in a suit thereon, by a subsequent holder, be permitted to deny the signature or capacity to contract of any prior party to the instrument. Again, I am repeating it. It says that no endorser of a negotiable instrument shall, in a suit thereon, by a subsequent holder, be permitted to deny the signature or capacity to contract of any prior party to the instrument, because title is transferred to the some other persons, he is entitled for further, you can say, the negotiation. The another very important the significance of the endorsement is the instruments will be only paid at maturity. As I have already mentioned before you that any instruments, the negotiable instruments which you have, that will be a subject matter of the negotiation, and it will be negotiated continuously until the payment will be made. So, the instruments will be only paid at maturity, that the amount will be, in case of the bill of exchange, that will be given or the payment will be made on the maturity only. Another significance is that it says further the endorser by his act of endorsing promises to indemnify the endorsee or any subsequent holder for any loss suffered by him on the dishonour of the instrument, provided the procedure necessary of dishonour has been duly followed. Again, I am repeating it. See, the another very important significance of the endorsement is that the endorser, the person who is endorsing it, by his act of endorsing, promises to indemnify the endorsee or any subsequent holder for any loss suffered by him on the dishonour of the instrument, provided the procedure necessary to dishonour has been duly followed. That means, as a endorser, I am taking, or you can say I am extending the kind of the promises to the next to whom I am delivering the documents, means towards the endorsee. I am not restricting my liability towards it. If the dishonoring, the instruments is dishonoring in any regions, if it is not, the payment has not been made, I am also not free from to discharge my liability. It is not that I have transferred the documents, so my liability is over. The endorsement is talking about no, it is a kind of, you can say, support which will be continue. So, that the very beautiful significance. In addition to the above, an endorsement carries with it a right of further negotiation to the endorsee along with the right of ownership. Thus, the significance of a simple signature that constitutes an endorsement is more than the purpose it serves, namely the transfer of the instrument. That again, the very important things is that, as I have told you, the significance when we are talking about, then it begins from the 2-3 things. The one, if we will see that it creates the entitlement. The second thing which I have discussed with you, that it checks the genuinity of the documents. And the third, as I have told you, that all the previous endorsements were genuine under section 122 of the Negotiable Instruments Act, and it states that the instrument, the endorser cannot exempt from its liability. But when we will discuss the kinds of endorsement, then that right has been conferred. But at that moment, that the endorsement he cannot withdraw from his liability. And then I have told you that the instruments will be, you can say, the payment will be made only at the maturity. And the last one which I have discussed with you, that is the when he is acting, the endorser when he is acting, or you can say that he is endorsing, he is making other promises to indemnify the endorsee or any subsequent holder for any loss suffered by him on the dishonor of the instrument, provided the procedure necessary on dishonor has been duly followed. That is why, as I have conclusion, I have mentioned that in addition to the above, the endorsement carries with it a right of further negotiation to the endorsee along with the right of ownership. Thus, the significance of the simple signature that constitutes an endorsement is more than the purpose it serves, namely the transfer of the instrument. So, it is not used as far as concerned that at the very beginning, as I have told you, it is nothing, it is putting at the signature. But the putting that signature, what kind of, you can say, the role played by your signature? It gives the entitlement. Not only it gives the entitlement in case of the loss suffered, that you are promising that I will fulfill that, and that you are also talking about by putting your signature how the payments will be done. And the very important thing through this, the process of endorsement, that you are talking about the genuineness of the documents. You are talking about, you are authenticating the genuineness of the instruments by putting or by making other persons, the endorsee, his entitlement, who will become, it gives the status of ownership, and being an ownership, he has the right to further negotiate. So, it will continue in that way. The third things which I have mentioned earlier also, that we will discuss about the kinds of endorsement. Although there are a little bit is a technical one, but we will see that how endorsement can be done and what are the how the endorsement can be categorized. As far as concerned the endorsement, when we are talking of the kinds of endorsement, it can be divided in the following category. The number one is the general endorsement or endorsement in blank. The general endorsement or endorsement in blank. Then the endorsement in full or a special endorsement. Endorsement in full or a special endorsement. The third one is very important, that is restrictive endorsement. And the fourth category is the partial endorsement, and the fifth category is the conditional or qualified endorsement. So, these are the kinds of endorsement that the last one is, that is per pro endorsement. So, scholarly it has been categorized in the 4 kinds, and these kinds we will discuss one by one. Again I am repeating it. The first kinds of the endorsement is the general or endorsement in blank. The second category, or you can say the kinds of endorsement, is the endorsement in full or a special endorsement. The third one, which plays a very significant role, its name itself indicates, that is the restrictive endorsement, and the fourth one is partial endorsement. The fifth one is conditional or qualified endorsement, and the last one is per pro endorsement. So, in that way we got that the 6 kinds of endorsement. Let us begin with the first one, the general endorsement or endorsement in blank. So, dear students, that has been defined under section 16 subsection 1 of the Act. Section 15 which talks about the definitions of endorsement, and the very, you can say, the subsequent section under section 16 subsection 1, it is talking about the endorsement in general or endorsement in blank. Let me allow to read out what says. Section 16 subsection 1 of the Negotiable Instruments Act 1881 states that if the endorsement signs his name only, again I am repeating it, as far as concerned the words which have been used under section 16 subsection 1 of the Negotiable Instruments Act 1881, it says that if the endorser signs his name only, the endorsement is said to be in blank. As an endorsement in blank, which is also known as a general endorsement, does not specify an endorsee, and such as the instruments become payable to the bearer. Now, let me explain it. When the person who is the holder, when he is putting his signature in that instruments, he has become a endorser. It is clear? Again I am repeating it. As a holder, when I intend to transfer that documents to some other person, as I have told you that transferability can be done by mere delivery of that instrument. So, but before transferring, when I am putting my signature on that instrument, then I engage myself on what? Under the process of endorsement. As soon as I put that signature, my capacity, or you can say the status, has changed automatically by signing on that instrument. So, the section 16 subsection 1 is talking about when the endorser is putting his signature only without mentioning the name or the other things. Simply he is putting his signature, and by putting his signature he is transferring to the other person. So, the negotiability is over, but as far as concerned that the endorsement is also taking place, because the previous holder, I can say, he put his signature, he has signed on this document. So, when he signed the documents, he is the endorser, his status is changed, he is the endorser, and the persons to whom he is delivering, he is become an endorsee. But he has not written anything. In that way, when the endorsement process is completed, that will called, that is the endorsement in blank, the endorsement in blank, and that is also called the general endorsement. Further, the section 54 of the Negotiable Instruments Act 1881 provides that subject to the provisions hereinafter continued as the cross checks, a negotiable instruments endorsed in blank is payable to the bearer thereof, even although originally payable to order. So, that if the name is not mentioned, it is all right, but he has put his signature, and if the person is presenting the check before the concerned branch, the paying banker will pay it even his name is not mentioned, because it is not necessary or it is not mandatory. So, the such kind of endorsement is called, that is the endorsement in blank or the general endorsement. So, the second category of endorsement, which is called the endorsement in full or a special endorsement, endorsement in full or a special endorsement. The endorsement in full or a special endorsement, it is also defined under section 16 subsection 1. Section 16 subsection 1 of the Negotiable Instruments Act 1881 states that if the endorser adds a directions to pay the amount mentioned in the instrument to or to the order of a specified person, the endorsement is said to be in full, and the person so specified is called the endorsee of the instrument. Now, the very interesting thing which I like to share with you, in the previous, when we are talking about the general, when he is transferred, so you can say that the name is not mentioned. So, the persons who got that, he is entitled to get the payment, but I find concern that it is very difficult, sometimes we find that it is very difficult to get the actual, you can say, the ownership of it, because his name is not mentioned. That is very important, we will have to keep in mind. On the other hand, when we are talking of the endorsement in full, the endorsement in full, when we are comparing with the endorsement in blank and the endorsement in full, then we will find that it will entitle the other person. As a possession or the possessing of the documents you are entitled, you can be called as the holder, but as far as concerned the endorsement process which will give, or you can say the authenticate of your ownership. But if your name is not appeared in the documents, you can be a holder, you are entitled to get the payment, but it's sometime it creates some sort of, you can say, the question mark that whether you can transferring the documents at that time you are putting your signature. So, it also not barring as far as concerned the endorsement under the process of endorsement, but as far as concerned that it is preferable that to give the better title to the you can say the endorsee, it would be better under the process of endorsement that the endorsement must be done on a full endorsement, but as far as concerned the act provides itself, the endorsement can be done in a blank also, and the same sections is talking about both the process of endorsement, the endorsement in blank or endorsement in full. The difference between these two, in the first cases only the holder is putting his signature and transferring it to the other without mentioning anything, even he is not mentioning the other's name. But in case of the full, the endorser is mentioning his name, the pay to B, for example, pay to B, and he is handing over the documents to the B, then the B is entitled because his name is appeared in the documents. As a holder, now he got his rights entitlement by full endorsement, it creates the another kind of, you can say, the entitlement. But I am not saying that as a holder, because you have taken from that, you have received from the previous holder. So, there is no doubt about as far as the title is not defective, but as far as concerned that to exercise further rights, the some sort of questions is raised in case of the blank endorsement. But as far as concerned the Negotiable Instruments Act, the person said that right, as a holder you can exercise that rights that you can transfer further. So, but as far as concerned when we are talking about the full endorsement, under the full endorsement that is putting the person's name and he is putting his signature, then only he is transferring. When he is doing that kind of, you can say, when the endorser is doing such kind of activities, then we are calling at the such endorsement is called the full endorsement, or the persons to whom the documents is given, he will be the endorsee of the instrument. So, endorsement in full is otherwise called the special endorsement. So, it is also called the special endorsement. So, that is why I have included the endorsement in full or a special endorsement. For example, if A, the holder of a check, desires to make an endorsement in full in favor of B, he may write pay B or order, or pay B and then sign it. In both the cases, the instrument shall be deemed to be payable to B or to his order. In the previous case, in case of the general, these words are not there, and the persons who is possessing the documents, he cannot claim at the time, you can say that I can further endorse it, but it is permissible as a holder, he can further negotiate it. But as far as concerned the full endorsement, the endorser is authenticating you by putting your name and by putting his signature in the instruments, and then he is delivering. So, we engage or involve in the full endorsement or a special endorsement. The effect of an endorsement in full is that the instrument can be paid only to endorsee and can be further negotiated only by his endorsement. The instrument retains its other character. But as far as concerned that you can say the general endorsement, such kind of, you can say, the things will not create. But as far as concerned that the full endorsement, see how the beautifully, or you can say vitification of the full endorsement. As soon as it received by the endorsee is become what you can say that he becomes the owner of that, because it gives the ownership, and being an owner that he has a right to further negotiate. The holder of an instrument may convert an endorsement into in blank into an endorsement in full by adding the name of the persons above the endorser's signatures. For example, a check is endorsed in blank by A and is transferred to B. B may convert the endorsement in full by adding the words pay B or order or A's signature over A's signature and thus prefer to become endorsee himself. In such a case, however, if B wants to negotiable a check further to C, he will have to endorse it. See, the consequences as I have told you, that is the persons if might be that intentionally or he left in that way. But the endorsee, even in case of the blank endorsement, he can put his name. There is no restrictions because only putting his name, it will authenticate you that you are the genuine or you the title is given to you. So, that above the signature of the previous holder, if it is given to you in a general you can say the endorsement, the endorsee have that right, the endorsee have that right that he can put his name, the pay, the B because it is given to B. So, he can write that above the signature of the endorser and he can make entitlement, and once he put his name over that, he can now he is entitled and he can further negotiate because it becomes a full endorsement. Alternatively, B may straightway write the words pay to C or order or A's signature and transfer it to C. The right is given to the holder under section 49 of the Negotiable Instruments Act 1881, which states that. Let me allow to read out the provisions which he made under section 49 of the Negotiable Instruments, which talks about the rights of a holder. The holder of negotiable instruments endorse in blank may, without signing his own name, by writing above the endorser's signature a directions to pay to any other persons as endorsee, on avert the endorsement in blank into an endorsement in full, and the holder does not thereby incur any responsibility of an endorser. So, the section 49 empowers the holder if he got any kind of you can say any endorsee, if any instrument from the anyone, and if it is in the blank, he can convert it into the full and he can transfer further. Now, the another section which is very important as far concerned to at this juncture, that is the section 55 of the Negotiable Instruments Act. The section 55 of the Negotiable Instruments Act, it says, if a negotiable instruments after having been endorsed in blank is endorsed in full, the amount of it cannot be claimed from the endorser in full except by the persons to whom it has been endorsed in full or by one who derives title through such person. For example, a check is endorsed in blank by A and transferred to B, who endorses it in favor of C. The latter transfer it without any endorsement to D. If the check is dishonored, D cannot be sued B or C. He is entitled to sue against the A. The reason behind it, because their names are not appear. So, how he knows by that? So, that responsibility, to create responsibility towards them under section 55, it is very important that the endorsement must be done and full. Now, the third kind of endorsement, that is the restrictive endorsement. The restrictive endorsement, the name itself indicates that the restrictions can be made, or another kind of you can say that we will read the another kinds of the endorsement, that is conditional, where we can put the conditions also. So, let me allow to express or explain the what is the nature of the restrictive endorsement. An endorsement constitutes the endorsee the owner of the instrument and also confers upon him the right to further negotiation. It is a general character of you can say the endorsement. As soon as the endorsement completed, the persons or you can say the holder have a right that he can further negotiate, because it gives the entitlement, it gives the ownership rights. But when this right is further negotiation by express words in the endorsement restricted or taken away, that is called restrictive endorsement. According to section 50 of the Negotiable Instruments Act 1881 provides that the endorsement of a negotiable instrument followed by delivery transferred to the endorsee the property therein with the right of further negotiation. But the endorsement may be express words, restrict or exclude such rights, or may merely constitute the endorsee an agent to the endorse the instrument or to receive its contents for the endorser or for some other specified persons. Again I am repeating it. Section 50 states about that the endorsement of a negotiable instruments followed by delivery transferred to the endorsee the property therein with the right of further negotiation. There is no question about it. But it further says, but the endorsement may be express words, restrict or exclude such right, or may merely constitute the endorsee an agent to endorse the instrument or to receive its contents for the endorser or for some other specified person. That the persons, when he can exclude his liability by mentioning that he is not a part of it. So, or even he can restrict further negotiation by mentioning that further not negotiated. So, restrictive, the kinds of, you can say that the endorsement, it permits to the holder that he can put such kind of conditions and even he can stop the further negotiation. So, in that way it restricts the further negotiation. The restrictions can be put, and when other persons is putting some sort of the restrictions on the process of any, you can say the instrument at the time of endorsing, that will comes under the definitions, or that kind of, you can say the endorsement we will call it, that is restrictive endorsement. The fourth kind of endorsement, that is partial endorsement. Partial endorsement is also very important, and it says a partial endorsement is one which purpose to transfer only a part of the amount payable under the instrument, or which purpose to transfer the instruments to two or more endorsees. So, if it is the at the time of making an endorser, for example, A is a holder, or you can say the endorser of an instrument, and he is making that the payment will be made proportionately, the certain, you can say the he has mentioned suppose 500 rupees, the instruments contain the 500 rupees, he will say that the pay to rupees 200 to A and pay the remaining amount, that is 300, pay to B. So, what he is doing, that the partially he is doing it, the partially the payment, the partially the entitlement he is making the partially, he is not making the entitlement to one. So, the when such kind of, you can say the instructions at the time of making an endorsement, if he is putting such kind of, you can say the conditions that will comes under the definition of a partial endorsement. As far as concerned the partial endorsement, section 56 added the provisions of it, and section 56 of the Negotiable Instruments Act 1881 provides that no writing on a negotiable instruments is valid for the purpose of negotiation of such ring products to transfer only a part of the amount appearing to be due on the instrument, but where such amount has been partly paid, a note to the effect may be endorsed on the instrument, which may then be negotiated for the balance. So, that negotiable instruments, when we are talking about, there is the very important things that there will no any kind of the conditions, it must be unconditional. But here when you are making the responsible partially to someone, that if it is there, then it will be a part of the partial endorsement. Law recognizes only an endorsement of the entire amount of the instrument, hence partial endorsement is not valid, but it is a kind of, you can say, endorsement. But as far as concerned, when we are talking about how, because as I have told you that the conditionals you cannot do like this, the partially, that is why it is not can be done, it is not a valid one. It says the law recognizes only an endorsement of the entire amount of the instrument, not the partial or not the remaining amount, hence the partial endorsement is not valid. For example, as I have already cited before you, a check for rupees 500 in endorsed by D. David as follows: pay to Lakshman rupees 100 only and pay to Raman rupees 400 only. So, that is the partially he is endorsing in the partial way. So, the validity of the endorsement is doubtful, even though the entire amount has been endorsed, that he is not, there is no any kind of the remaining amount is. The total amount 500, that is the entitlement is given to the two persons, but it is talking about the validity of the endorsement is doubtful. Even though the entire amount has been endorsed, the endorsement in their favor is partial and invalid, but where a bill of exchange has been paid in part, it may be endorsed for the balance. As far as concerned that the bill of exchange that can be possible, but in case of the check that cannot be make such kind of order to the banker. The fifth one is the conditional or qualified endorsement. As I have told you that the conditions can be put, and the such kind of, when you are putting the conditions, that is empowered, you can say, or the holder can have that right under section 52 of the Negotiable Instruments Act. So, what do you mean by the conditional or qualified endorsement? A conditional endorsement is one whereby the endorser excludes or limits his liability. That he is putting some sort of the conditions. By putting his that kind of the conditions, he is limiting its liability towards the that instruments. So, if such things or if such kind of the conditions has been put by the endorser, that endorsement will come under the definition of the conditional or qualified endorsement. It says the conditional endorsement is one whereby the endorser excludes or limits his liability to the endorsee, or which makes the transfer of the property in the instrument depend on the fulfillment of a stated condition. As one concerned further, as I have told you, that it supports, or you can say the powers, or you can say the right can be exercised with the help of section 52 of the Negotiable Instruments Act 1881. Let me allow to read out the provisions of section 52. Section 52 of the Negotiable Instruments Act 1881 provides that the endorser of a negotiable instrument may, by express words, in the endorsement exclude his own liability thereon, or make such liability or the right of the endorsee to receive the amount due thereon depend upon the happening of a specified event, although such event may never happen. So, if we will see that this particular provisions, it is talking about that by putting some sort of, you can say, the instructions, by putting some sort of the conditions through which the endorser can limit, or you can say the lessen its liability by making such kind of endorsement. That is the reason we are calling about it that it is a conditional or qualified endorsement. As per question the qualified or the conditional endorsement, let me explain the few examples. When an endorser so excludes his liability and afterwards becomes the holder of the instruments, all intermediate endorsers are liable to him. Again I am repeating it, that when an endorser so excludes his liability and afterwards become the holder of the instrument, all intermediate endorsers are liable to him. Liable to him. The two illustrations which I like to put before you, the first illustration is that the endorser of a negotiable instrument signs his name, adding the words without recourse. Upon this endorsement, he incurs no liability. Now, suppose A, when he is endorsing and he is trying to escape his liability, to discharge his liability from that instruments, so he can endorse in that way. When he is endorsing in that way, that will comes under the definition of a conditional endorsement. And as I have cited the example, when the endorser in the negotiable instrument, he is putting his name, adding to the words without recourse. Upon this endorsement, he incurs no liability. The another example we can take, the A is the payee and holder of a negotiable instrument. Again I am repeating it. A is the payee and holder of the negotiable instrument, excluding personal liability by endorsement without recourse. He transfers the instruments to B, and B endorses to C, who endorses it to A. A is not only reinstated in the former rights, but had the rights of the endorsee against the B and C, but he is not liable under, because he has already mentioned that it is not his liability, that he can put some sort of the events only on the completion of that events the payment can be made. So, such kind of conditions when ever the endorser is putting, that is a kind of, you can say, the endorsement or the qualified endorsement or the conditional endorsement. A conditional endorsement may take place in any of the following ways. There are the three kind, or you can say the circumstances where the conditional endorsements will take place. The endorsement sans recourse. If the endorser does not want to incur any liability as endorser, he can insert a stipulations in his endorsement negative or limiting his liability. He may, for example, write his endorsement thus: pay D or order without recourse to me. Specifically he is mentioned, and if when he is mentioning such kind of things, that will comes under the conditional, and that conditions is made under the circumstances of endorsement sans recourse, and expressly he has denied to take any kind of responsibility to continue, and he says the pay D or order without recourse to me. If any loss occurred, I am not responsible for it. Or he is mentioning pay D or order sans recourse, or he is mentioning pay D or order at his own risk. There is no minor risk. You pay him, and it is only that you can, if any loss occurred or if any, you can say, the documents is dishonored. So, I am not responsible, the D is responsible, because I have already mentioned on the documents itself at the time of endorsing. So, that becomes the endorsement sans recourse. These words will exclude the liability of the endorser altogether. They may any party prior to such endorser. The second condition is talking about the sans phrase endorsement, sans phrase FRIS endorsement. Sans phrase means without expense. Here the endorser does not want any expense to be incurred on his account on the instrument. This is, the endorser accepts his liability for the amount of the instrument, but he does not want any additional expenditure like noting or protesting charges to be borne by him. For example, A endorses the check as follows: pay to B or order without expense to me. So, he is responsible to the amount which appeared in that, and any kind of, you can say, the incidental charge which taking place, he is excluded his liability from that. The third category, that is, or you can say the conditional, the endorsement can be done through that, and that is called the facultative endorsement. Now, the endorsers under the facultative endorsement, what the endorser is doing? The endorser, like the drawer, may expressly waive some or all of the holder's duties. For example, he may waive his right to receive due notice of dishonour or waive due presentment of the instrument by the holder for payment. Such type of endorsement known as facultative endorsement. In such cases, however, the endorser continues to be liable to the endorsee if the instrument is dishonoured. That is in the third category, as far as concerned the facultative endorsement, under the conditional endorsement, it will not exempt from the liability, but they may, you can say that the liability which is required, if the dishonour is taking place, then what is the liability towards the payee? The payee has to inform to the drawer or whoever may be the endorser, previous endorser. So, someone may, they do not want to take such kind of the responsibility, he may take the, you can say, the privileges which has been granted in terms of the facultative endorsement, he can waive his name from this kind of the responsibility. I would like to put one example in this regard. The facultative endorsement might read as follows: pay to B or order, notice of dishonour waived. He already mentioned that the notice of dishonour waived. If the dishonour is taking place, it is not responsibility to the maker that he will, or you can say the payee, that the payee will inform to the drawer. He will not do that. Normally, when a bill is dishonoured, notice of dishonour should be served by the holder to all the previous parties. But in the above example, the holder can, without serving any notice to the drawer, make him liable in case of the bill is dishonoured. So, very beautifully that plays a very significant role if at the time of endorsement, if you are using such kind of words, it will exempt from your liability. Then the per pro endorsement. The per pro endorsement, it's a kinds of endorsement which is an endorsement made by an authorized agent. It is not made by the endorser, but the endorser can the authorize someone. He is making, when he is making such kind of endorsement, that endorsement is called the per pro endorsement. There are some of the legal provisions which related to the endorsement, which I like to share with you. That is the following, you can say the Negotiable Instruments Act is providing some sort of the legal responsibility, or even the legal provisions relating to the endorsement. That is just the section 50 of the Act of Negotiable Instruments, which is talking about the effect of endorsement. It said the endorsement of a negotiable instruments followed by delivery, transfer to the endorsee to the property therein with the right of further negotiation, as you have already discussed, that is given under section 50 of the Act. As an endorser, the every sole maker, drawer, payee or endorsee, or all of several joint makers, drawers, payees or endorsees of a negotiable instruments may endorse and negotiate the same. As I have told you that they got the title of ownership. As a owner, that right he can access in that way. Now, the time factor is very important as far as concerned the Negotiable Instruments Act, and as far as concerned the endorsement, the section 60 is talking about it. According to section 60 of the Negotiable Instruments Act 1881, a negotiable instrument may be negotiated except by the maker, drawer, drawee or acceptor after maturity until payment or satisfaction thereof by the maker, drawer or acceptor at or after maturity, but not after such payment or satisfaction. But entire the process of, you can say, the negotiation, that can be checked by the persons until the payment is satisfaction, or thereby the maker, drawer or acceptor at or after maturity, but not after the payment or satisfaction. If the payment has been done, that cannot be checked. Then the fourth, you can say the liability as far as concerned, that is talking about the endorsement of a part of the amount. That is very important. As we have already discussed, the partially it cannot be said, that will be treated as the invalid one. So, section 56 talks about that. The instrument must be endorsed for its entire amount, not for what we can say the partially. So, section 56 of the Negotiable Instruments Act 1881 provides that no writing on a negotiable instrument is valid for the purpose of negotiation of such writing, purpose to transfer only a part of the amount appearing to be due on the instrument. So, it must be made with the full, not. As far as concerned, the regularity is very important in any endorsement. So, the last part of the portions of this lecture, that is the regularity of the endorsement. An endorsement must be regular and valid in order to be effective. The appropriate or otherwise of the particular form of endorsement depends upon the practice among the bankers. The following rules are usually followed in this regard. The signature on the document for the purpose of endorsement must be that of the endorser or any other persons who is duly authorized to endorse on this behalf. If a check is payable to two persons, both of them should sign their names in their own handwriting. If the endorser signs in the block letter, it will not be considered of a regular endorsement. The second thing which is very important, that is all endorsements should be either made only in ink, although it is not written, but there is chances if you will make it in the pencil, that the chances of alteration is there. It has been held that it can be done through the even in the typewritten form, or as I have told you that it can be done by putting the rubber stamp endorsement there. So, in that way that we can understand that the endorsement as far as concerned playing a very significant role to authenticate the parties of the negotiable instruments. As you have seen that it creates the liability, at the same time it creates some sort of the rights towards the parties of the negotiable instruments. Thank you very much.